Welcome to the CCI Grand River Podcast. I'm Michelle Dyer. Thank you to RLB LLP for our lovely podcast studio. However, for the next 2 episodes, we're taking it outside the studio. Recently, the CCI Education Committee put together the finest legal minds of the chapter and had them in a room with a live audience to discuss a legal year in review. They got together and talked about, debated, relevant and interesting cases brought forth and ruled on by the Condominium Authority Tribunal in 2022. For those of you not familiar, the CAT is an online tribunal dedicated to resolving and deciding condominium-related disputes in Ontario. So needless to say, this event sold out quickly, and we are bringing it to you in its entirety over the next 2 episodes. 2 things you should know. The following is not legal advice. The legal panel is discussing the results from cases already heard by the CAT. If you have condominium concerns that you feel may require legal advice, please contact a lawyer directly. Second, you should know this couldn't have been possible without our sponsors. Thank you, Cohen Highley Lawyers, Criterium Jansen, Edwards Community Management, MF Property Management, Registon Building Restorations, Robson Carpenter LLP, Shibley Righton LLP, SV Law, Wilson Blanchard Management, and Woodhouse Restorations. Kick back, grab your favorite drink and snack, and enjoy the first part of our 2-part legal panel, A Year in Review.
Hello, welcome to this beautiful venue and our chapter's first legal year in review. My name is Jamie Poudry. I'm one of the VPs at MF Property, and I'm also a member of CCI Grand River Chapter's Education Committee. When I volunteered to moderate this session, we were just getting back into the swing of in-person events, and I thought there would be like 20 or 25 people. But welcome to all 100 of you. We sold out this event and sold out this venue, so that is really great. So it feels amazing to be able to gather in a place like this. It's been a very long couple of years. I'm not going to mention the C word, but I've been really impressed with CCI and that they've been able to offer education continually over the last couple of years. And we've also had really high participation rates from our members, so that's been amazing. This will be the last education session for 2022, but stay tuned for lots more for 2023. So the legal panel event has always been a really popular crowd favorite, so I'm just going to give a quick thank you to all of our sponsors, and then we'll get right into the session. We have Wilson Blanchard Property Management, Robson Carpenter LLP, Edwards Community Management, Cohen Highley Lawyers, MF Property Management, Shibley Righton LLP, Registon Building Restoration, and SV Law. So just a quick hand for their support in making this possible. So onto the panel. First up, we have Stephanie Sutherland. She's an associate lawyer at Cohen Highley LLP. She practices in the area of condominium development, residential and commercial real estate, and commercial litigation, and has plenty of experience with various courts and tribunals, which is always necessary for condos. Patrick Greco is a partner at Shibley Righton in the Condominium Law Practice Group. He works as a solicitor to condo managers and boards, and his background in litigation also comes in handy in condo land. Annie Bailey is a land development lawyer with Robson Carpenter. She was born and raised in the KW area and is very committed to supporting condo development in Kitchener-Waterloo. And last but not least, we have Rob Mullin. He is a lawyer at SV Law. He regularly works with boards, managers, and developers, and is also active in the field of municipal law and land use development. So before we get started, I'm just going to ask that you hold questions until the end of each speaker. We'll probably have to limit the number of questions, but depending on time, we can open up the floor at the end. I do not think these lawyers like to talk a lot at all, so I'm assuming we'll end right on time. And lastly, our usual disclaimer that anything they say today does not constitute legal advice. You should always contact your lawyer for your specific situation, preferably not during the question and answer session at the end. So, over to you, Stephanie.
Okay, so I'm going to get right into my couple of cases. Okay, I'm going to be talking about the cat and dogs. My first case is Tamil and Metropolitan Toronto Condominium Corporation, number 844. And in this case, there was an issue of competing disabilities. So there was an owner who had claimed that he required an emotional support animal. The condo did a thorough investigation, requested the evidence necessary to establish a disability and to establish that an emotional support animal was required to accommodate that disability. And once they did the investigation, they were satisfied that was the case. But then another owner, because this is no pet building, another owner was not happy about that, and she claimed that she had severe and life-threatening allergies, and that the dog being in the building was impacting, significantly her life and her safety. So the condo tried to do an investigation with her, asked her for all of the evidence. She kind of provided a very general doctor's note, but nothing that would have met the standard of establishing that there was actually a disability, and especially a disability to the extent that the dog that was living in a completely separate unit was impacting her and needed to be removed. So went to the cat, the owner with the allergies did the application, and the decision ultimately was that because the condo had done such a thorough investigation with respect to the emotional support animal, had gathered all the evidence and was satisfied, and the owner complaining about allergies had not properly participated in that investigation and provided the evidence, the cat found that while her allergies may constitute a disability, she had not proven that it was severe and life-threatening like she claimed, and she had also not proven that she was suffering from undue hardship. So her application was dismissed. So takeaway from this one is that when you're dealing with any disability claim, make sure to do a thorough investigation. Don't overstep. There's information that you're not allowed to get. You're not allowed to ask for specifically what the disability is. But you are allowed to require evidence as to what accommodation is required and how the accommodation that they are requesting, whether it be a pet or a ramp or anything, how that is going to address and accommodate their needs. I guess this is especially important when you're dealing with competing disabilities, because then you are going to need to establish and figure out whether one is going to have to take priority over the other. My question is, and I'd be curious also to hear from the others on the panel about this, is what would have happened if she was able to prove that it was severe and life-threatening allergies and that she was suffering from undue hardship? I suspect that the cat probably would have said, well, in your case, it's actually potentially life-threatening, so the dog's got to go. But I guess until we get a case where there's actually been a thorough investigation of both, we won't know for sure. Okay, so my next one is Toronto Standard Condominium Corporation number 2208, and case, and I said during our preparation meeting that I was going to learn how to say this name and I forgot. I think it's Casey, but I don't know. Apologies. So in this case, an off-leash dog, owners had just moved into the building relatively recently. Their large off-leash dog had gotten into an altercation with and injured another smaller dog, which was also off-leash, and neither of them were allowed to be off-leash. So because of this incident, the owners paid the vet bills. The city issued a dangerous dog order requiring the dog to be on leash, and they had to put a notice on the door, etc. And the owners complied with all of that. But what the owners did not comply with was when the condo decided that, or the board determined that the dog was a nuisance under the provision in their declaration. And so the condo went to the cat because the owner refused to comply. And the cat's decision was that the board did not do a proper and thorough investigation, and so the cat overturned the board's decision. I have a lot of opinions on this, and I'm sure my fellow panel members do too. So there are a few problems with this, in my view. The first is that the cat actually considered evidence that was not before the board when the condo board was making their decision. And if we're treating this as essentially an appeal, which, really this was an appeal of the board's decision, appeal courts aren't allowed to consider evidence that wasn't before the original deciding board or court or whatever. So in my view, that was inappropriate. The CAT felt that the board really had not done a thorough investigation, so they didn't talk to witnesses, they didn't look at the security feed, etc. And so, I mean, I understand where the tribunal was coming from, but a board is not a tribunal. They are not held to the same standards of investigation. They're not professionals, at least with respect to carrying out legal investigations. So I don't think they should have been held to the same standard. And finally, the provision that the condo was relying on specifically said that the board had the absolute discretion to determine whether the dog was a nuisance. In my mind, absolute discretion means absolute discretion, and the board gets to make that decision. But apparently the CAT disagreed. So, takeaways, this should have been appealed. I wish it had been. Does anybody know if it was? I don't think it was. No, I wish it had been. Boards should do basic investigations when there are incidents and altercations. I think in this case, even if it wasn't required, it probably would have behooved the condo board to talk to some of the witnesses and check the security feeds if it was there. It's always a good idea to have all of the information at least. The other issue, and I suspect this is a big part actually of why the CAT found the way it did against the condo, is that the condo brought the application and then didn't really participate. None of the board members put in evidence.